All rise. The Court of Appeal in the 45th District of the State of Florida is now in session. The Honorable James A. Edwards, Judge presiding. All persons having business before this court draw near to the attention and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning, everybody. We have 3 cases today, and I just want to introduce the panel. Judge Carrie E. Weidner to my right, and Judge Howard Maltz to my left. He's here from St. Johns County, where he serves as a circuit judge. So, with our civil cases, if you'll let me know what you want in terms of rebuttal time, I'll set you up, and we'll go ahead and start with our first case, the Depositors Insurance Company versus the beach scene. What would you like for rebuttal, counsel?
5 minutes, Your Honor. May it please the court, my name is Ezekiel Lugo, and I represent the appellant in this case, Depositors Insurance Company. This time I'd like to reserve 5 minutes for rebuttal. The error in this case is on page 290 of the record, on paragraph 3, where the trial court ignored the plain language of the policy and instead applied the prejudice analysis that has been applied in cases involving breaches of post-loss obligations when the insurance company does not, or the insurance policy does not specify the consequence for such a breach. That is not the kind of insurance policy provision at issue in this case. The trial court should have enforced the plain language of the policy, found that there was no coverage in this case, denied summary judgment for the plaintiff, and entered summary judgment for depositors.
Let me ask you, you say there's no requirement of prejudice. Let me give you an example. Say the alarm company had called the business and said, we got to do repairs. The alarm system won't be working for 2 hours tomorrow from 1 to 3. And the owner says, that's fine. We'll have a couple people here in the store, so that won't be a problem. Just let me know when the repairs are done, and it goes off without a hitch. But they don't call the insurance company and give them notice that the alarm system's down for, well, it was down for 2 hours. And there's a burglary later on. Is that, could the insurance company deny coverage there?
Well, the insurance company shouldn't deny coverage under that situation, Judge Evander, because in your example, if there's no notice given that they're going to come and do that repair, the insurance is automatically suspended when the repairs are begun, and it's reinstated when the repairs are concluded.
Well, but in your brief, you said it became void. But I understand the word suspension. So in my example, say there was a theft that occurred during the 2 hours.
In that situation, then there would be no coverage for that particular theft. That would be like the situation in this case where the alarm monitoring contract was terminated not within an hour or 2 hour span. It was terminated 3 weeks before the loss ever occurred.
About my example, because your argument is that prejudice is never required. So if there was a theft within that 2 hours, even though they had 3 or 4 people in the store, and even if the insured could show that the insurance company would have taken no action if they'd gotten that type of notice that the alarm system would be down for 2 hours, but there'd be employees in the store, you're saying that they could deny coverage even though there'd clearly be no prejudice there.
Under the case law, they could deny coverage, and the cases we're relying on in particular for that proposition are the current decision that this court issued and how it was applied and interpreted in the former decision, where this court wrote that in the absence of explicit policy language specifying the consequence for the breach, then the prejudice analysis is relevant and applied.
So if the policy used the term rendered void rather than suspended, then under your example, or the example I just gave you, if it was down for 2 hours and, repaired in that 2 hours and there were employees in the store and then there was a theft 3 hours or 3 weeks later, under what you're arguing, that would mean that the insurance company could deny coverage and say, 3 weeks ago it was down for 2 hours and even though you had the store manned, you didn't...
Well, Judge Evander, I don't think that was the argument in the brief. In the brief, we rely on the language saying the policy was automatically suspended, and I believe in the facts section,
If we follow your argument that prejudice is not a factor, then that would be the result, wouldn't it?
Not under the language in this policy, because it's talking about suspension. It's only suspended while the breach is in place, while the protective safeguard is not maintained, and when there's no notice provided to the insurance company.
Breach?
It's a material breach, Judge Evander, because it goes to the essence of the bargain in this case, which is the insurance company says, we're going to provide coverage for this particular kind of risk. In this case, a risk when there is a alarm monitoring contract in place and when you agree to provide notice and to keep it in place. In exchange for that promise, the policyholder receives a significant reduction in the premium. So when there's a reduction in the premium and an agreement that we're going to limit the coverage to the particular situation when there's an alarm contract in place and when there's notice given that there's been an impairment, then that goes to the heart of the bargain. It goes to the essence of the case of the contract, and the contract itself, it specifies that the coverage will be automatically suspended. It specifies the breach.
The insurer in the policy language, though, says if you choose not to maintain this, at our option, we can keep you insured, basically at a higher premium. You won't get the discount. It's not automatically, we will not insure you. It's not like a restaurant. If you don't have fire extinguishing equipment, we're not going to cover you at all. It's the discount. Why wouldn't it then be, if instead of being suspended automatically where there's no prejudice in terms of the event, why wouldn't it be the insurance company would be entitled to charge the greater premium, the non-discount?
But for the insurance to be able to do that, Judge Edwards, it would have to have notice that there's been an impairment, so that it can then make the decision to either maintain the insurance at its option or to decide to charge an increased premium. In this case, depositors knew that there was a risk that this contract, the monitoring contract, would be terminated in October. The alarm monitoring contract gave them notice. They decided not to pay for that contract, and then on November 27, they got a letter that it had been terminated. They did not give notice to depositors.
Which act was it that suspended the policy? Was it the failure to maintain the monitored insurance policy, or was it the failure to notify your client that the insurance or the alarm was not being monitored?
Well, Judge Walt, it is our argument, and one of the 2 points I want to make this morning is that under the plain language of the policy, it was both of the acts alone and taken together, which resulted in the suspension of the coverage. The plain language...
How does the failure to maintain the alarm, setting aside the notice, how does the failure to maintain the alarm automatically suspend the policy under the terms of the policy?
Judge Moss, it goes back to the language that Judge Edwards was mentioning, and it is that in the protective safeguards endorsement, the first substantive provision is a notice, and it's in boldface and in all capitals letter. It says that the CC&C risks the loss of insurance coverage if it does not maintain that protective safeguard. The next paragraph, the next sentence, gives the language that Judge Edwards mentioned, which is, at our option, then we can decide, if you give us notice, that we're going to keep the coverage in place and charge an increased premium, or we're not going to maintain the coverage. So under the notice part of the provision, and under subsection A, which says that the maintenance of the protective safeguard is a condition to the policy, when the policyholder fails to maintain it, then the property coverage is lost. Then under subsection B, the plain language says you have to give us notice when either you fail to maintain the protective safeguard or you know that there's an impairment. And in those situations, the insurance will be automatically suspended. The same language is included in the property declarations portion of the policy, which says if you do not give us notice, this insurance is going to be automatically suspended. The trial court was required to give the plain language of the policy. Under Florida law, courts have to give the plain language of an insurance policy effect. And when the courts do not do that, that is a serious error. It is a serious mistake. And
Let me ask you this. You're arguing that prejudice is not required, and the concern I have in that regard is immaterial breaches can become a basis for forfeiture of coverage. But on the other hand, I'm not convinced by the appellee's argument that you examine prejudice with the nature of how the loss occurred. Isn't the real issue here whether there's prejudice when you evaluate prejudice, as far as you all not having the opportunity to either cancel the insurance or to increase the premium, isn't that where if the prejudice occurs, isn't that where the prejudice occurred?
I think that's tied to the analysis in current that this court said has to be performed, and that goes to my second point. These cases talking about the prejudice analysis when there's been a breach of a policy condition, the 5 cases that the trial court cited and the 14 or 15 cases cited in a long string cite in the answer brief, they were all cases that involved a post-loss obligation, where the loss has already taken place, and then there is a failure by the policyholder in the 5 cases cited by the court to either give notice of the loss or to give a proof of loss. Those provisions, those post-loss obligations, are generally grouped together with the insured's duty to cooperate, which traditionally under Florida law has required a prejudice analysis. And this court in current said the first thing that has to be done is the court has to look at the provision at issue, and it has to look at what kind of provision it is and where it's grouped in the insurance policy. In this case, it's not a post-loss obligation. It is an obligation that was undertaken at the inception of the policy, where in exchange for that exchange in the premium, the policyholder agreed that they would have this protective safeguard in place.
How do you distinguish the independent fire insurance versus NC&B bank case? Because that's a pre-loss case, isn't it, where you're dealing with an increased hazard and the insured was accused of not reporting, or the mortgagee was accused of not reporting the increased hazard. I mean, it seems rather similar to this case.
At first blush, Judge Edwards, it does, but the court has to look at what was the analysis and what were the issues in that case. And in that case, the court, the ruling that the court gave was based on the decision that the consequence language was ambiguous, that the policy would be void, and it was ambiguous because there were 2 things or 3 things that the insured had to do, and it wasn't clear whether the insured had done one or the other. Now, the court, once it decided that the language was ambiguous, still explained that if neither one of the conditions had been performed, then there would be a forfeiture. The court remanded it back to the trial court because it wasn't clear whether the insurance company had been prejudiced or which of the provisions had been breached. And I think the prejudice envisioned in that court is what Judge Weidner is mentioning, which is whether there was notice and an opportunity for the insurance company to cancel the insurance in its entirety or to charge an increased premium. And if that's the best case that the policyholders have, then the same analysis should apply in this case, and they're still not entitled to summary judgment because it's undisputed that the alarm monitoring contract was impaired, there was no notice provided, there was no opportunity at all for depositors to decide whether to maintain the insurance or to charge an extra premium. Now, going back to the current analysis, the second part that has to be performed is the court has to look at whether there is language specifying the consequence for the forfeiture. And in the current decision and in the Farmer decision, there was no such language. So this court held because the policy provision is a post-loss obligation, which is similar to a breach of a cooperation clause, and because the policy does not specify the consequence, then the prejudice analysis is relevant. This case is more like the Oretsky decision from the Southern District of Florida, where in that case, the policyholder agreed at the inception of the policy that he will keep his Maserati within an enclosed, attached, and locked garage. And the policyholder decided he would keep his Maserati outside, parked in the driveway. At that point, the district court decided there had been a breach. It was before the loss, unlike in current. The court also looked at the policy language, which said if you do not keep your car within that locked garage, then the insurance coverage is forfeited. So the district court distinguished current for the second reason that the policy in that case specified the consequence for the loss.
It didn't stop there, though. It went ahead to look and discuss, well, if your Maserati had been in the garage, maybe the crook wouldn't have seen it. The reason you parked it outside instead of leaving it in the garage, you knew it'd make a lot of noise and wake up your son. I mean, if it was that clear cut, I would think the district judge down there has better things to do than just chat away. I mean, it's got to have some meaning for the judge to have gone on into that analysis, doesn't it?
Well, Judge Rosenbaum was given that additional ground in case, I assume, I don't know, I wasn't there, that the 11th Circuit would review the case and there would be two grounds to affirm her decision. And on appeal, the Federal District Court did not reverse her analysis of Curran. It affirmed the ultimate result, and it also looked at the prejudice and said, even if prejudice is relevant, there is prejudice in this case. Now, if this court is concerned that prejudice is relevant, then Judge Vander's analysis and the analysis from the NCMB case should perhaps apply, and this case would need to go back to determine if there wasn't any opportunity for the insurance company to decide whether to keep the coverage or charge an increased premium. And with that, I would, unless the court has any other questions, I would reserve the remainder of my time for rebuttal. Thank you.
Good morning.
Morning.
I think I can address a couple of the questions that were asked as to whether or not there had been an opportunity to increase the premium, that type of thing. That's not one of the grounds they ever raised in the trial court as to prejudice. They raised two grounds for prejudice. The first one was that they weren't able to pursue some subrogation action that doesn't exist. It's an imaginary subrogation action. And we showed that in our papers. And the second is, the only prejudice they mentioned was they had refunded the premium, and I cited the case that says...
The trial judge awarded your client summary judgment, which says there's no material issues.
Yes, sir.
Of disputed fact. And the trial judge also determined that where you look for prejudice is the nature of how the burglary occurred. And...
That's how it was framed.
Why isn't that an incorrect analysis? Why isn't the correct analysis looking at the fact that they were denied the opportunity to either cancel the policy or increase the lease? Isn't that where you look for prejudice?
They didn't raise that as a ground. And so when they didn't raise it, it's certainly not something that we dealt with.
But the trial judge granted your client's summary judgment as a matter of law.
Yes, sir, and it was cross motions for summary judgment.
I know.
They were arguing that there was no they ultimately, in their second motion for reconsideration, said there's no prejudice as a matter of law. We showed that there was prejudice. We showed that's not true. And as this court did in Curran, and as the Supreme Court did, they said, based on the facts in the case, we don't need to send it back for an analysis of prejudice, because based on these facts, there is no prejudice. And so the Fifth did that, and when it went up, the Supreme Court did the same thing. The Supreme Court did the exact same thing in the Tideke case. It's a 1969 case. Both sides have cited it. And in that case, the court said, and Curran cites it, it is unnecessary to remand the case for a determination of prejudice where the record amply establishes no prejudice to the insurer. And here, yes, sir.
Doesn't common sense tell you that the prejudice is that they meaning the insurance company, is unknowingly insuring a risk that they don't know about, that being a business without a monitored burglary?
Right. They didn't raise that, but I will address that. First of all, the policy says you may risk loss of coverage. You risk it, not it shall be. In this particular case, the facts are the monitoring contract, the policy says you have to have an approved monitoring contract. It was never submitted for approval. The insurance company never asked to see it. It was fine with them. So they waived that. They waive these things all the time. If they wanted to raise this as an issue, they should have done so at the lower court level instead of raising the two issues that they did raise. And then there's another issue. When we look at the Axis case out of the second DCA, or if we look at the other prejudice cases, Axis says there has to be a substantial prejudice. They can't come in here and say it's a nickel different premium. And they had their opportunity to do that. We had summary judgment. They had their first motion for reconsideration. They had their second motion for reconsideration over a year later. They had an opportunity to present evidence that they were prejudiced in the way you're both asking about, and they didn't do it.
Well, what are the facts in the record that establish prejudice or lack of prejudice if you examine prejudice at the time of your client's failure to give notice to the insurance company? What is in the record, if anything?
The one thing is, we know they waived the approved monitoring contract. You're asking as to this premium question, or you're asking as to the facts of the burglar? Because
Well, your client didn't give notice at the time that they failed to pay. So the insurance company did not have the opportunity to take whatever action they may have taken. What evidence is in the record as far as whether they were prejudiced by that or not? Or what evidence is there a lack of prejudice? Because you had, in your summary judgment, you had the burden of showing a lack of a disputed fact. On their summary judgment motion, they had the burden.
what we did is took the facts, all the facts that are in the record, and analyzed the prejudice. That's not one of the facts that they raised. They didn't put on, there was no deposition, there was no affidavit, there was nothing from them that said there would have been a material, and it has to be material. The independent fire case also says it can't be an immaterial change in circumstance. It can't be an immaterial change in the premium. AXA says it has to be a substantial prejudice. There was no evidence that they would have raised the premium. All the policy says is you risk the loss of this coverage.
So you're saying there could be no disputed fact because they never raised that fact?
It was,
that issue?
we did discovery, we did a stipulation of the facts that were relevant to both sides. We submitted that to the court. That's what they thought was relevant, that's what we thought was relevant. Both sides said, Judge, based on these facts, will you make a decision in this case so we don't have to go try
We're
this?
not bound by the fact that there's cross motions for summary
I understand.
judgment. I mean, would you agree that the trial judge analyzed this prejudice at the wrong point of time?
No, I don't. Because if you look at every case and you evaluate whether or not there's after the contract is formed. If this happened before the contract was formed, and then you look at 627409, it has to be a material misrepresentation that would have affected the amount of the premium, or they wouldn't have issued the policy. That statute focuses on pre-formation conduct by the parties. They would still have to demonstrate it was a material misrepresentation. They can't come in and say the premium, we might have issued it at a different premium. We could have, and it may have been an immaterial amount.
Stipulated facts, you all agree that they got a reduced premium because of the protective safeguards provision.
That is correct. That's what the policy says. There's no evidence that if
But that was stipulated, that was in y'all's stipulated statement of facts.
It was, and it's part of, it says that in the policy, that sentence, and that's where that came from. But at that point, they don't have, there's no evidence whatsoever, and they could have presented some. There's none. Those are the facts that they say were relevant for this decision, and what they said is, Judge decided on these facts. And they can't come in here now and say, here's an additional ground that they didn't argue.
But you agree the trial judge determined there's no prejudice because of the stipulation that the burglary would have occurred anyway and the
Yes, sir.
alarm system wouldn't have detected it?
Yes, sir. And one thing...
Your position that that's the correct analysis here?
Yes, sir. And if...
Isn't that contrary to the independent case that you cited and the...
Here. What they said there, it's the same clause. It's the notification clause. You got to notify us, and if you don't, then the policy shall be null and void. So that one's even stronger than ours. And what they've said there is the failure to give the notice that increases the hazard is an affirmative defense which places the burden on the insurer to prove that such notice was required. They never pled it. They've never pled that. And how can we be here 3 years later for them to raise it for the first time? They had to at least plead it.
Well, let me ask you about the Glades Flying Club case.
Yes, sir.
I know you, in your brief, point out they don't use the word prejudice anywhere, but they do say, the court there says, there need be no causal connection between the non-compliance and the loss or injury. Here, I think it seems to me to be very much the same. The party stipulated that there's no causal relationship between the loss and the fact that the burglar alarm was not being monitored. So why doesn't Glades Flying Club tell us you're wrong?
Well, if it was directly on point, your job, I guess, would be, all right, are we going to follow independent fire, or are we going to follow Glades? But Glades isn't on point. Glades, there was never a prejudice discussion, maybe because the insured's lawyer looks at it at the beginning of the case and goes, well, there is prejudice. Maybe there, I'm looking at it and go, how would I, as a policyholder's lawyer, argue there's no prejudice when you have an unlicensed, unqualified flyer who crashes a plane? So maybe they just abandoned that before ever filing suit.
He's not unlicensed, he's not unqualified, he just doesn't have a current medical certificate, and there's no evidence that he had a medical condition that caused the crash. I mean, that's what it's a short discussion, but that's what I get from it.
And I see that, but apparently they decided, the policyholder's lawyer decided not to raise prejudice for some reason. I don't know if the background facts were what they were, did not raise it. If they had, maybe it's different, but ultimately the court's only decision was it's not ambiguous. So when they took this case, they said, we're not going to deal with prejudice, or maybe he didn't realize it and didn't do it. Maybe it was intentional, but they only dealt with ambiguity.
But the causal connection language in there, you think that's just pure dicta?
I do, because why would it be in there absent when there's no prejudice analysis? That goes to the prejudice analysis, certainly. It has to be dicta, because that's the only thing it would be related to is a prejudice analysis.
Well, even the independent fire, where they talked about you have to do a prejudice analysis, it's a reverse to remand for a factual determination of whether there's prejudice.
Yes, sir. In a totally different circumstance. It was pled, I assume. Here it's not been pled. They never pled prejudice. They raised it for the first time in their second motion for reconsideration, and they can't raise it here. I mean, we dealt with the two grounds that they did raise then, but how can they raise it here for the first time? I do want to address real quickly, I think it's an interesting analysis. They continually say the fifth DCA's decision in Kern. You got to look at that, because the fifth DCA in their certified question puts in parens, in the absence of contractual language specifying the consequences of the breach. That somehow is a different analysis. When you have the nothing in it about what's going to happen, that you do this prejudice analysis, but if there's a consequence in the policy, then you don't look at the prejudice. It's very interesting. If you take the Supreme Court's certified question, they rephrased it, and they took that part out. And they don't mention this. So what they say in the rephrased certified question, they take out this part that says in the absence of contractual language specifying the consequence of breach, and they rephrase it to simply say where an insured breaches, in this case it was the CME provision, in an insurance policy. They take out that language and they go, does the insured forfeit benefits under the contract without regard to prejudice? And then if there is a prejudice analysis, who has the burden of proof? And so I just wanted to bring that up, because I do cite the 5th DCA current opinion multiple times to say that where you have a consequence spelled out in the policy, you don't do the prejudice analysis. Well, the Supreme Court took that out of the certified question and answered it broadly.
Of course, we really need to say the plurality of the Supreme Court.
Yeah.
One thing that's interesting is you both refer to below as condition preceding rather than condition subsequent. And you both might be right, I don't know. But 3 justices think you're wrong by their definition, but not 4. So I don't know where that leaves us.
The reason I did that is, Farmer case is my case. And so in Farmer, this was the analysis we did. And in Farmer, there was a consequence. It says we will not pay for any loss, and you can't sue us if you don't do the proof of loss. And so there is a consequence. The Axis case is a consequence. It says we won't pay for any code upgrades if they're not completed within 2 years. Certainly that went to the premium calculated in Axis, the 2nd DCA case. And yet the 2nd DCA said, hey, the fact that you didn't rebuild until several years later is okay if there's no prejudice, and in that case they said there is no prejudice. And it wasn't a premium analysis. It was, is there prejudice to the insured? If it's a premium analysis, first of all, they didn't plead it. They didn't argue it. There's no evidence of it, but it'd have to be a material difference, and there isn't one. Let me check my notes quickly. No, they don't have one case, not one case, that says we don't do a prejudice analysis. Not one.
Let me ask you a question.
Yes, sir.
real quick. The trial court found there to be no ambiguity in the policy. You don't address that in your brief, and you did not cross-appeal on that issue. Do you agree with the trial court's analysis on that?
I did not, but I thought we were strong enough on this and get us focused on what this issue is, on the prejudice analysis. They didn't plead it, they didn't raise it until a year after the summary judgment, and so we went with that. But the definition of maintenance, maintaining, and the definition of the central alarm, what that is, we did lose on that issue, and we didn't appeal it. Okay? I don't have anything further. Thank you for your time.
May it please the court, Judge Waltz, the point you made in the last question is important. They lost the issue as to whether the policy was ambiguous. They did not cross-appeal that point. They did not raise it in their brief. It's waived. It's abandoned. The plain language of the policy is clear and unambiguous. The trial court was required to give effect to that language. It did not do so. That was clear error.
Could you address the argument Mr. Nation made about a waiver, that you did not argue prejudice as far as the opportunity to increase the premium or to cancel below, and therefore you can't raise it here?
Well, Judge Evander, the heart of the argument was what I just said. The plain language of the policy applies and controls, and the plain language of the policy has the language that Judge Edwards mentioned during my main presentation, which ties the loss of the risk, the failure to notify, to giving the opportunity to the depositors to decide at its option whether to maintain this coverage in place or whether to increase the premium. On summary judgment, the standard of review is that every inference has to be interpreted or looked at in the light most favorable to a non-moving party, depositors. That language from the policy was part of the stipulation. It was Exhibit A. In the burden on summary judgment, they had to refute the inference from that language that depositors needed to have an opportunity to have notice of the impairment so that it could decide whether to keep the coverage in place or whether to charge an increased premium. That did not happen. That is prejudice under the facts, the stipulated facts of this case that they did not refute on summary judgment.
Were there any facts in there about what the insurance company would have done had they gotten a call? In other words, here's our track record, we always cancel them, we always...
No, Your Honor, there is no such evidence because our argument was prejudice does not apply. The prejudice analysis that they are citing from the post-loss obligation cases does not apply. It does not apply. There was no...
proof on proving prejudice, though.
It depends on whether it's a condition precedent or a condition subsequent, and the parties agreed and stipulated below that it was a condition precedent. So depositors was not required to plead or prove or submit any summary judgment evidence on that point. The language of the policy, which is in the record, part of the stipulation agreed to by the parties, required the depositors have an opportunity to decide whether to keep this coverage in place or whether to charge a premium. That did not happen. They did not refute that point. They were tied into the factual connection, the causal connection between the loss and the breach in this case, which is not relevant under the Glades case, which was argued below. Now, the opposing counsel mentioned a couple cases. The Axis case out of the second DCA, that case is distinguishable. That was a case about waiver. The insurance company waived the provision at issue when it helped the policyholder to try to get the repairs performed within a certain amount of time. The 2 years went out. The insurance company didn't complain, didn't say anything, and then after the fact, it tried to raise this provision at issue. The case was decided on waiver. The prejudice analysis was dicta tacked on at the end and not really developed. The Tiepke case that he mentioned is a case dealing with a post-loss obligation, the failure to give notice, which is not what we have at issue in this case. And then he spent a lot of time talking about the current opinion from the Florida Supreme Court. And Judge Vander, like you mentioned, that's a plurality opinion. We're not sure exactly what the Florida Supreme Court meant. And the fourth DCA in the Rodrigo case has decided that that current opinion is limited to CME provisions in UM policies, which is not what we have in this case. That case was tried to be, they petitioned for review to the Florida Supreme Court, arguing that it was in conflict with current. The Florida Supreme Court decided not to accept that case.
Let me ask you this. On the condition proceeding, certainly probably the clearest example of the condition proceeding is a requirement that you truthfully and accurately fill out an application for an insurance policy, correct? Would you agree with that? And even if you had a provision that said if you're not fully truthful and accurate, this policy is void, wouldn't there still be a requirement to show that any inaccurate statement in an application was material?
Well, Judge Vander, that's controlled by statute. There is a statute that says when you're trying to assert a breach based on a failure to give correct information at the application stage, you have to meet a certain burden to show a particular kind of prejudice. That's a statute that does not apply in this case. This case is most similar and closer to Oretsky, which opposing counsel didn't address. That is the analysis that should apply. This is not a post-loss obligation.
The 11th Circuit did go into prejudice analysis.
But only after finding that prejudice is not relevant, Your Honor. The heart of the Oretsky decisions is that prejudice is not relevant. And then for the sake of argument, hypothetically, to indulge the argument made by the appellant, the court goes ahead and looks at prejudice. If this court wants to do the same thing, then the prejudice is we didn't have notice. We couldn't decide whether to maintain the coverage or charge a premium. For all these reasons, Your Honors, we respectfully request that you reverse the summary judgment for CC&C and remand this case to the trial court. Thank you.
Thank you. Well argued and brief. Thanks.
Thank you.